I'm Robert Gilligan. I work with the Minick Law firm. Our firm practices in the area of personal injury, workers' compensation, family law, and criminal law. Today I'm going to be talking with you about family law, specifically in the area of separation agreements. Quite often people come to my office together looking for a divorce. Perhaps they've resolved all of their personal conflicts, they know exactly what they want, and they're ready to just move on with the rest of their lives while trying to be amicable. A separation agreement is simply an agreement drawn up by two people who were previously married that simply states a division of their property, what they agree is going to be separate upon entry of a divorce. This is especially helpful for people who want to avoid the cost of litigating out every tedious detail of their assets, their debts, and their child custody arrangement. In North Carolina, there are two types of divorce. There's no-fault divorce and fault-based divorce, the vast majority of which are no-fault divorces. When entering a no-fault divorce, a judge is required to make findings of fact, and a separation agreement can be pointed to as the conclusive element of all of those different findings. This prevents a judge from going through and deciding who gets the dog, who gets the child on what day, or who ends up paying what particular debts. It's generally a good idea to try and start a divorce action or some separation action with a separation agreement attempt. In many ways, formulating a separation agreement can start as the template for the issues that are going to come out in a divorce. A judge will typically accept a separation agreement as it's been drafted and agreed upon. However, it is entirely up to the judge's discretion and the judge's sole discretion as to whether or not the terms in that separation agreement are equitable. So if the separation agreement, for example, is grossly inequitable to the other party, a judge could refuse to enter that as part of your agreement or as part of your divorce. A separation agreement is also unable to guarantee a certain amount or lack thereof of child support payable to either party, as that is within the judge's discretion and is set to a certain extent by statute. So in other words, you could both agree that the other party might pay $0 a month for child support. However, a judge could overturn that and mandate that one parent pay child support for the other parent. By entering into a separation agreement in the early part of your separation, you can conclusively wrap up into a nice package all of the issues that you believe will become contentious or possibly contentious down the road. As a general rule, it's best to try and negotiate a settlement agreement when the two of you are on the most amicable terms that you possibly can be. Generally speaking, this means resolving your issues in the earlier part of your separation rather than towards the end, where most people have potentially developed some alternative relationship or have another person that's intertwined in their life that just further complicates the emotional stressors on the particular relationship. The Minick Law firm is standing by, ready to help you with any of your legal needs regarding emergency custody.